Welcome to our Guildford Chambers talk this evening. I'm going to speak first on the subject of parental children with my colleague Suzanne Kelly. I'm going to be setting out a private children case law update on subjects that you see on the screen. And Suzanne is then going to be speaking to you more in depth on the subject of parental alienation. So turning to our first subject of forgive me a moment, we haven't technical issue, that's not where we should be. I think these must be the subject that Suzanne is speaking on. Here we are. So our first subject then of background hearing as a case of REA. The fact in this case, this was an appeal related to fact-finding that taken place in the High Court, considering the mother's allegations. She made 41 allegations under the 7 headings that you see on the screen, and the appeal was focused on 3 grounds. That the judge failed to consider the relevance of her findings of abandonment and stranding to never allegations. There was a flawed approach to the other evidence and insufficient reasons for those findings, and that it was wrong to refuse to adjourn for an intermediary assessment, which was failure to take account of the mother's vulnerability when assessing her evidence. The judgment sets out the principle in relation to the role of the appellate court in relation to fact-finding decisions. That being, in the absence of some other identifiable error, an appellate court will only interfere with findings of fact made by a trial judge if it is satisfied that the decision cannot reasonably be explained or justified. The appeal is useful in that it provides a reminder of how different allegations are to be analysed and assessed in isolation, but also collectively. The judgment looked at treatment of different allegations, and you have the full quote on the screen, but picking out the bits that are essential, the judge said that it's entirely possible for it to prefer the evidence of one witness on some issues and another witness on other issues, and that sometimes the correct finding will be a surprising one, but provided there is an appropriately robust explanation, it's entirely open to the court to make it. The judgment also comments on the connection between different allegations, again, all quotes on the slide, picking out the relevant part. Instead, and despite her correct self-direction, she treated the various limbs, like the mother's allegations, as if they existed in unelected compartments, so much so that I accept counsel's submission about the stranding allegation and finding about it being invisible elsewhere in the judgment. Staying on the same topic, but we've launched in case of A and C. This is another field following fact-finding. The law set out in paragraphs 21 to 22 of the judgment in relation to consideration of evidence and the circumstances in which the appellate court will interfere. The judgment sets out what we're looking for in terms of a fact-finding judgment. So, notwithstanding the concerns discussed relating to to part of the judge's reasoning, he made findings based on the whole of the evidence, applied correct legal principles, and made no errors of law or fact that undermined or contaminated his conclusions. I do not regard the judgment as having been rationally unsupported. Moving on to our second topic of parental responsibility. This was a case about a sperm donor, a case of refusal. It's a little older than most of the rest of the cases I'll be talking to you about this evening, but it does have some very interesting points to note. The background is set out in front of you on the screen of the accusations, and I will move quickly on to the applications and issues, because those are where the interesting point lies. The decision considered whether there should be a Section 9140 order, and whether the child that JM has named should be published. The mother and the guardian both supported naming him. The law is set out within the judgment. I won't cover with the detail at this juncture, but the outcomes are where the relevant law lies. JM spent some time with the child's R when that child was born. the judge had reservations about JM's motivation for seeking PR in contact, and thought that a large part of his motivation in making the application was to control the mothers and to control their lives. The judge found that the granting of PR and contact was being detrimental to R's mother, and therefore would have had a very negative impact on R's welfare. In relation to P, the judge refused an order for PR and contact. JM had never met with or seen that child. The last child, N, the judge said it would be detrimental to N's welfare for him to have contact with JM, given that the impact it would have on the mother. Letterbox contact was not considered appropriate, as JM would likely use it as a method of gaining information and for indirect influence and control over compliance. The other issues were the Section 9140 application. The court negative order in this case for 3 years to prevent the mothers from being further traumatised by applications. And it was accepted that whilst unusual, in this case it was appropriate for JM to be named, as there was sufficiently great interest, public interest in naming JM, which outweighed the risk of identification for children and their Article 8 right to privacy. The judge had no confidence that JM would not act as a sperm donor in the future, and equally had no confidence that he would fully explain to any woman the true implications of his Fragile X syndrome. There was therefore a very specific benefit to him being named in the hopes that women would be looking up on the internet to see the judge vote. That's a very nice segue into our third topic of Section 9114 orders. Firstly, the case of F and M. This was a long-running case. The father applied for orders in 2017, and in January of 2021, very serious findings were made against him and coerced and employing behaviour. The case continued, and the court noted that challenges and obstacles to the smooth and timely resolution of the case had been almost entirely the father's making. The case finally came before the court to deal with the father's question of contact. I'm being asked about my microphone. And two interesting points are discussed within the judgment, the Section 9114 orders and the question of no contact orders. The history and purpose of Section 9114 orders is considered a paragraph 18, and you'd have that full text within the slides in front of us. Piecing out, again, the important parts from it, but referring to the case of Brie R., the court was of the view that Section 9114 orders had always been intended to provide a protective filter from inappropriate applications. The filter existed to provide the child, and not infrequently the parent with whom the child lives. It is not a punitive measure towards a recalcitrant parent, neither is it a bar on access to justice. The court noted that the discussion in Re A of Section 91A, paragraph 2, which had not yet come into force at the time of judgment, and how it dovetailed with the moderate approach made from Section 9114 orders, where the making of a Children Act application would put the parent or child at risk of harm. The court further noted the concept of lawfare that was identified in Re A, and suggested that there was the less reluctance on the court's part to step in and to make an order stop what is in essence a form of coercive control. Paragraph 20, we come to the court's view of provisions under Section 91A. The court described the section as transformative, a powerful tool with which judges can protect both children and the parents whom they live, and recognising the very significant role protracted litigation can have on children and individuals who may already have become vulnerable for a variety of reasons. There's a warning contained within it that lawyers and judges must be assiduous to identify when this occurs in order to ensure that the court is not manipulated into becoming a source of harm, but rather a guarantee of protection. In that case, Section 9114 order was put in place until the youngest child reached 18, taking into account the nature of the identified harm. The judgment also instituted saying there's no contact orders. CAFCAS recommended to man or letter, but in evidence, the CAFCAS officer said that if the parents had not been married, she would have recommended verification of the father's parental responsibility. The court questioned why she was recommending any contact and felt that the CAFCAS officer had reverted to general principles without wheeling them into the particular circumstances of this deeply troubling case. He said that it was a professional, indeed a human instinct, to preserve some thread, however vestigial, that leaves open options for a child who does not have contact with a parent. No order was made for contact. The court could not identify any benefit and instead thought that either indirect contact might be unsettling and potentially harmful both to the mother and child. The judge concluded with the observation that there are occasions where it is necessary to recognise a disagreeable truth. There is sometimes, though very rarely, a parent who has nothing to offer a child and who the child is better off without. This is such a case. Staying with the topic of Section 914 orders, this time the case at E and G. This concerned a 13-year-old girl who was named as X. The case is in and out of court from 2012 until the decision this year. And father throughout was fixated on the idea of 50-50 shared care. In 2012, he was given 8 nights out of 14. 2016, that was reduced to 5 in the Section 91 and 14 order was made. It was reduced again in 2020 when he was given 3 nights, and again in the Section 91 14 order was made. In 2021, the mother applied herself. Previous arrangements were suspended due to the father's non-compliance with the previous order, and as a final hearing took place in May and June of last year, the court again rejected a 50-50 split of time, but continued the 2020 order, adding further time on Wednesdays, and was clear that X wanted an end to the litigation. Unfortunately, not 6 weeks later, the matter was back in court. The father had continued to see the child outside of ordered contact, and the mother alleged that he had assaulted her. Contact was again suspended, whereas the father again defied the orders and continued to meet with the child. The guardian applied for the father's committal, and a suspended order was made. The father continued to seek 50-50 care. Mother and the guardian wanted less so had only. In the end, shared care was rejected because it had been repeatedly rejected by previous judges throughout the case. And the court was not satisfied that shared care was what X wanted. He also thought that it would increase the father's control and the risk of conflict. The judge considered the various options open, but in the end concluded that there should be letterbox contact for anyone specific. Our first topic is the question of submission to relocate, and this is the case of Louis N. This is a first instance decision, but there's a comprehensive judgment considering the applicability of the welfare checklist in respect of the contested issues. The judge was asked to answer the questions on the slide, and the court provided the principles that you would expect of the welfare checklist and relating to relocations, particularly regarding how to the case of Louis F. The principles are summarised in paragraph 9 of the judgment. In applying the principles of the case in the evidence presented, the judge stated these divisions are nearly always finely balanced, and this case is no different. Our fifth topic is that of instruction and experts in the case of Reed GV. This was an appeal following a case management decision permitting the instruction of an expert. The guardian had applied for permission to put expert evidence before the court supported by the father but opposed by the mother. The court permitted the instruction of the expert to embark on a global psychological assessment of both parents and children. As part of the application, the judge approved the questions for the expert to address, including the questions that you held free. The grounds of appeal were that the judge was wrong to order a psychological assessment, which invites the expert to determine the actual matrix of disputed allegations, but the judge was wrong to order a psychological assessment of the parents and the children without considering the tested necessities, and the judge had failed to give any reasons for ordering a psychological assessment. The court set out the ambit of judicial discretion, saying that the court should not interfere with the exercise of the judge's discretion, except if it is outside the generous ambit of discretion vested in the decision maker at first instance. It's the essence of such discretion that on the same evidence, two different minds might reach widely differing decisions without ever being appealable. It's only where the decision exceeds the generous ambit within which reasonable disagreement is possible, and it is in fact role, that an appellate body is entitled to fit. The judgment also comments on the limits of the expert's remit. Again, you have full quotes here, but strange to the heart of the matter. It is the court's function to make factual determinations necessary to perform welfare decisions in the trials, not to delegate that role to an expert. Our sixth topic is that of evidence and disclosure, starting with the case of Greek Dead. Findings of abuse were made against the father in her case, and he was a social worker. Social Work England applied to a transcript of the judgment as part of their own internal investigations into his fitness to practice, and that application was refused. The court remade the decision rather than remitting it, concluding that the decisions of public safety outweighed the father's right to respect for privacy. The judge had erred in not inviting further information or submissions from the Social Work England before making his decision, and the decision that Social Work England could conduct its own investigation in the absence of the judgment was misconceived. The information, it was thought, should be told in the family court, rather than a child's identity and confidentiality being the subject of South West England's own processes. General guidance is given up in paragraph 65 of the documents. Second case on the subject is the case of Lee-O. The father in this case was concerned about self-incrimination. Findings had been made against him, and he was awaiting trial in criminal proceedings. He refused to discuss the findings that had been made with the Section 7 report author, and his solicitors wrote to the court ahead of the final hearing, expressing his concern that he could not participate in that final hearing due to the privilege against self-incrimination. The court held that there was a fair process open to him, the children's lives could not be put on hold pending the outcome of the criminal proceedings, and that his privilege against self-incrimination did not stop him advancing his case, including giving or challenging evidence. The last topic is the question of participation, and firstly, in relation to the QLRS. I've set out on the screen an extract from the President's view from July 23. It's set out there that despite the scheme being widely welcomed initially, it's not been able to attract a sufficient number of advocates. The courts obviously need to determine how to proceed in the absence of a QLR if one has been ordered. And the President suggests that if no QLR can be found within 28 days, the court should list a directions hearing and direct that summary information be provided by HMCTS about the difficulties that have been encountered. There's no real guidance as to the test to be applied to discharge the requirement for a QLR, but the interest of justice test is the focus when appointing one. The President suggests that a similar focus may be appropriate when considering a discharge of the QLR, as well as the overriding objective. He points out a short reason should be given as in the order of determination of the appointment. In place of the QLR, other options will have to be explored, and this is an example directly instructing the advocate. There is guidance against default conducting the cross-examination of a witness itself, but that does not trump the overriding objective. So it may well be that the court has to revert to the position of conducting that cross-examination itself if there is no alternative. The case of D and R is about participation directions. This was a fact-finding hearing over 4 days. The mother's allegations were not proven and she appealed, and the ground centred on court's failure in terms of participation directions. The court had not been addressed or independently considered Part 3A or Practice Direction 3AA. Despite that, the appeal was allowed on Barrels 1 and 2 because the rules are clear and they place the mandatory obligation on the court to consider vulnerability. No ground rule hearing took place. The court did not consider participation directions, and the combination of the failure to consider Part 3A together with the lack of reference or consideration of the mother's vulnerability in the judgment had the consequence that the hearing was unfair and the conclusions could not therefore remain safe. The findings were set aside and the matter was remitted to be heard by a different judge. There's a clear warning within that judgment that consideration of the requirements of Part 3A and practice section 3AA should now be embedded in the legal landscape of these cases to ensure the important safeguards they provide are kept under active reviews. The second case on a similar subject is the case of SPNCN. This is another fact-finding hearing, and again, the mother's findings were not made. In this case, there had been participation directions. The mother's case was put that the court should not say that this allegation was untrue or false unless there was a finding to that effect was specifically sought. The court disagreed and said that the judge must have the capacity to say that the allegations were untrue. The mother also argued that unless an allegation as party had falsified an allegation was put to those, the judge was not allowed to say the allegation was false. That also was rejected. The mother's complaint flashed lack of gravity role, someone, and her complaints that the participation directions were not implemented were also rejected. The issue was never raised during the hearing, and any lapse had not made the trial process unfair or put the mother at disadvantage. Finally, the mother argued that the patient must have proceeded when she was 33 weeks pregnant. She had agreed to continue and, in fact, had wanted to do so, and no complaint had been made by her counsel or solicitors before it had made clear that the baby's health was take priority, and again, her argument was rejected. The last case on this subject was the case 3T, and that relates to service on party life refuge. There's an obvious tension between the need for service and to safeguard those who take refuge. There's been no provision, and there had been no provision in the FPR, no authorities and no guidance on the approach to be taken in such cases. So the refuge concerns, as well as Women's Aid and the Secretary of State were asked to intervene. Pending consideration by the FPR committee, guidance was given by Sir Andrew McFarlane, as set out on the slide. Service at a refuge should only be required in circumstances that are exceptional and urgent. In all other cases, an alternative means of service should be used. Such alternatives are set out then in paragraph C. Participation directions as translation should be considered. The alleged perpetrator or their representatives must never themselves personally serve at a refuge or be given the address, even with an undertaking. Where personal services to be made to the refuge, it should be undertaken by court bailiff or the tip staff using female officers and plain clothing, and any formal contact with the refuge should engage the CEO or director of the refuge rather than his staff. Lastly, a comment on IZVA and ISVA tenders. The default position is that they should be allowed to attend proceedings, and that should only be passed on to the interest of justice. Thank you, Phyllis. And I will now pass you to Suzanne. Good evening. So I'm going to be talking to you this evening about parental alienation. In particular, two particular cases that have been reported of one where the judgment is going to be, but has not yet, as it's such a recent case. So starting off, what is parental alienation? As family practitioners, it's something that we will have heard our clients say to us time and time again, and it probably, in my experience, is probably the second most put out allegation against a party, second to domestic abuse. Unfortunately, unhelpfully, there is no single definition of what parental alienation is, and there is some confusion that leads from that lack of consensus. What we do have is the 2019 guidance from CAFCAS, which defines parental alienation as being when a child has resistance or hostility to one parent is not justified and is the result of psychological manipulation by the other parent. And it's one of a number of reasons why a child may resist or reject spending time with one parent post-separation. Kafkas go on to say that alienating behaviours present themselves on a spectrum with varying impact on individual children, which requires a nuanced and holistic assessment. And it's helpful to bear in mind where there are allegations of parental alienation, that the court is likely going to be asked to make some findings, and an expert assessment is likely to be required in order for the court to establish the reasons that the child is refusing to attend contact. So, should children be joined to those proceedings? We see. We all know that it's often appropriate to make a child a party to proceedings. A Rule 16 for guardian can be sought. The Practice Direction 16A sets out when it would be reasonable and appropriate for a Rule 16 for guardian to be appointed. Usually where there's an intractable dispute over residence, or where there has all contact between one parent has ceased. The issue of joining a child to the proceedings, particularly in cases of parental alienation, is the delay. A delay to any child in proceedings is to be avoided, but those that are embroiled in the contentious proceedings between parents in cases of parental alienation, delays even more detrimental to their well-being. Although in recent years there is an increased appreciation of joining children to proceedings, it isn't a one case fits all, and the cases are each turn on their own facts. Quite often the children are not joined to proceedings, and in Re A and B, which we'll look at in a while, the judge refused on 2 occasions for those children in quite a serious case to be joined to the proceedings, considering it not to be in their best welfare interest, but also because of the additional delay that would cause. We all know that CAFCAS at the moment are taking 16 to 18 weeks in order to prepare Section 7 reports. So it's really important that we are all live to cases where we may be asking for children to be joined so that it can be done at the earliest of opportunities. So instruction of experts where parental alienation is a concern. The President in the case of Re C, which was the judgment handed down in February, he gave some very clear guidance, some principles that arose out of that. This was a case in which the mother sought to appeal a judge's refusal to reopen findings of fact that had been made in 2021. The mother and lastly the Association of Clinical Psychologists sought to argue that the expert who'd been instructed in those proceedings should never have been instructed. They were unqualified to give evidence on the issues raised in their instructions, and if a suitably qualified psychologist had been instructed, the outcomes and recommendations in a case when the children were removed from the mother and placed in the father's care would have been different. The judgment in Re C, therefore, focuses on the issue of the instruction of experts in proceedings where there's an allegation of parental alienation rather than parental alienation itself. In that particular case, there had been an order in March 2020 which made extensive provisions for interim contact and case management orders, and a recorder made the following provisions for instruction of an expert. The father had made an application, a Part 25 application, and his application was for either a child and adult psychiatrist or a child psychologist. The court found that it was necessary for there to be expert evidence and directed, strangely enough, that the discipline of the expert shall be either a child and adult psychiatrist or a psychologist. And that is the crux of the mother's appeal in this case, is in respect of the psychologist. The psychologist, Miss A, undertook her work in the summer of 2020. Her report was then filed in October 2020 and was plainly influential. she concluded that the children had been alienated against their father by the mother, and she considered that the eldest child showed such severe signs of alienation and that the younger sibling was on the same trajectory. So at a hearing on the 16th of October, Her Honour Judge Davies ordered the removal of the children from their mother's care and directed that there should be no contact between the mother and the children at all, pending a fuller hearing. The final hearing took place. Significant findings were made against the mother. The mother then sought permission to appeal, and that fact-finding element of the appeal, or the mother's first appeal, I should say, was refused by Mr. Justice Peel as being totally without merit. The mother then sought to instruct a further psychologist, and she identified one who rather strangely sent a letter to the court before any instruction had been made for him, criticising Miss A's work, criticising her qualifications, and saying she wasn't suitable to have given the opinion that she did. Her Honour Judge Davies dismissed the mother's application for further psychological expert, and said that she didn't need that, nor did she need any evidence from this psychologist who had written to the court in order to dismiss the mother's application and make the decision. So, although the case came before the court, an appeal was permission to appeal was granted. It was granted by Justice Peel in July 2022, not because the proposed appeal had a real prospect of success, but for some other compelling reason, and namely that it was in the public interest for the court to consider the instruction of unregulated psychologists as experts in the family court in general, and in particular Miss A's instruction in a case of parental alienation such as this. So in terms of definition of an expert in family proceedings, the President referred in his judgment, and it's quite nicely set out if I haven't got the time to read it. It's a very lengthy judgment, but there were multiple layers beforehand. But he refers to his own memorandum that he had published some 4 days before he gave this judgment, or 6 days before his judgment on the 4th of October. And he sets out there the basic principles of instructions of experts. So on the screen for you there, he said that his judgment doesn't or wasn't meant to alter what was set out in his memorandum. What came out of the judgment and his consideration of the various different practice directions, and it's from paragraphs 86 of his judgment onwards, where he draws together the guidance, and that incorporates the guidance from the Association of Child Psychologists as well. They've got very, very involved and interested in this case, and the way their skeleton argument put is set out in his judgment. I haven't got into it here, but it's well worth a read if you've got any time. And what the President confirms at paragraph 87 is that there is no definition of an expert in family proceedings, save for the procedural definitions that's set out in the rules. And he said an expert means a person who provides expert evidence for use in proceedings, and certain statutory exceptions to the term set out in the Children of Families Act. What was interesting and came out of this particular case is that in terms of psychologists, it's not a protected term, and I'll come on to it later. The protected terms are a clinical psychologist, a forensic psychologist, a child psychologist, anything that identifies in front of the word psychologist, but not it was seen the psychologist itself. And it's at the bottom of that particular slide there, at paragraph 93, where the President sets out what is the protected title. There is a list of all of them within the judgment, but a clinical psychologist is one. And what's interesting in this case was for the instruction of a psychologist. Although it was a child for adult psychiatrist, when it came to the psychologist, it just said psychologist. And that was what the mother is appealing against, an unregulated psychologist giving evidence. And what it says there is anyone can call themselves a psychologist. So you or I, Nicola, quick online course, 5 minutes later, can refer to ourselves as a psychologist. And there's nothing to stop that. But if we want to give evidence to the court, our report would have to be called a psychological report as opposed to an expert report. So in summary, in this case, the President notes there's a need for rigour during the process of identifying and approving an expert's instruction, and has indicated that the work should be done to assist parties and the court at the initial stage of choosing the expert by establishing a template. I don't believe I've seen one done yet, into which the basic qualifications of any psychologist should be entered. And there is some interesting guidance which was published by the Family Justice Council and is available, but it has a link, that is the link to it. So in terms of parental alienation, who decides whether or not a child has been alienated? And in receipt, the only part of the judgment that actually touched really specifically on parental alienation itself was these 2 paragraphs, where it's quite clear that the courts consider that it's not a diagnosis that can or should be offered by a psychologist. And the ACP's Association of Clinical Psychologists, he accepted what they had said, was that parental alienation is not a syndrome that's capable of being diagnosed, but it's a process of manipulation of children perpetrated by one parent against the other, and they were also termed as alienating behaviours. And it's the alienating behaviours that the President went on to say is what the court's focus should be. And fundamentally, it's a fact. It's a question of fact, and it's for the court to decide. But it does help us with what the definition we spoke about at the beginning is. What is parental alienation? It is alienating behaviours. So I want to talk now about when, I said when things go very wrong, and in terms of that, I mean things go very wrong for children and or a case parent. Re-C was followed in May of this year by Re-A and B. This case came before Mr. Justice Keenan. This is a case that went on for more than 4 years, and again, if you've got some time on your hands, but the various judgments, there are many, as you can see set out there, are worth a read. It is a really significant and serious case of parental alienation, and I'll come on to what the outcome of it was. But it also involved the instruction of a child psychiatrist this time, who's a renowned expert in parental alienation, and she worked in association with a colleague, Miss Woodall, at the specialist family separation clinics, and the family worked with the professionals for 15 months. Such was the mother's veracity in continuing the alienating behaviours that she engaged online presence that were abusive to Miss Woodall, and Miss Woodall is the specialist at the family separation clinic, suffered significant online abuse as a result of the same. Her work, however, was commended by the judge, and there was no fault found in anything that Miss Woodall had done. I say this case is of note, one, because of the complexity of the proceeding, but it also had, I say, just about every order that you could think of, and every twist and turn. There was a change of residence to the father, multiple appeals, and applications by the mother, all of which were unsuccessful. There were orders made against the Metropolitan Police to prevent them from interviewing with children, irrespective of some of the various allegations that the mother made were quite significant. The judge considered that the children had been so damaged by the mother and what she was forcing them to do, that he made an order that they could not be interviewed by the police. The police appealed that order successfully, and then some further orders were made that restricted how the children could be approached, but allowing the police to interview and speak to them. The father made an application for a Hodgkinson order, in light of the mother's continual non-compliance with any court orders. There was a freezing injunction made without notice of the mother's assets, and then the case ended with a prohibitive steps order preventing the mother from exercising any parental responsibility for being involved in the children's life in every way. In terms of what the father said, the father, Mr. Justice Keenan, he said, as far as I put it there, his conclusions is it's full, because it does set out, in summary, the quite shocking allegations the mother had the children made against the father. He said she orchestrated tracking with the children, and by that, it wasn't just tracking, it was knowing where they are, so she could send an unknown male to give them things and to ask them to make allegations against the father on the way to school and when they were going elsewhere. By making covert contact with them directly through the third party, so the unknown male, forcing them to make false allegations against their father or telling them to run away from the father and that she seriously abused child A and B. Parties of running away took place when the children were on a family holiday in America, and the children were told to go to the police. The mother had researched the law in the United States, and she told the children what to say one after the other to the police whilst they were in America. The allegations that she made, the children say that they had gone off to stay with somebody that they'd years, when in fact it was someone they'd never been with before, and they didn't want to stay with them, that they'd been hit by the father, that he had done all manner of things to them. The judge found that their mother had a distorted and false view of her children, her abusive role in their lives, and the devoted care given to them by their father. And he concluded that he was in no doubt that if this mother were ever again to have a role in the children's lives by contact or any other means, she would repeat her past abusive behaviours towards them without any regard for their well-being and their welfare. And it was with great sadness, he said he believed, having spoken to the children before and after they were separated from the mother, that it's imperative in their welfare, best interest, that she plays no further role of any description in their lives. Sadly, that's not the worst case or worst outcome when things go wrong for children in cases of parental alienation. And the case that I alluded to at the beginning is a case that has only just recently, because the experts in that case said it's the worst case of parental alienation that they had ever seen. It started off in private law proceedings. It ended up in public law. The reason that I bring it up this evening is that within those private law proceedings, significant findings of coercive, extreme coercive and controlling behaviour against the mother and the children by the father were made. A most unassuming man, the way he came across, but the findings were significant. The judge was so concerned in this case that he directed a Section 37 report. The author of the Section 37 report was provided with these quite significant findings and concluded that, yes, whilst the court may have found that there was parental alienation, did find there was parental alienation and coercive controlling behaviour, it wasn't such that there was any role for local authority. And so matters continued in the private law department. Things got worse to the extent that this child, who was living with a mother, so the alienation was by the non-resident parent, wouldn't speak to his mother, wouldn't eat any food that she cooked, wouldn't sit in the same room with her in the house, and frequently absconded and told her that she was abusive. He repeated the narrative that his father had given. So there was another Section 37 report in private law proceedings. And again, the Section 7 report also was provided with the findings and the judge's judgments in directing a further Section 37 report. And again, the local authority said, well, yeah, this is parental alienation. It's there, the court's found it. but he's having contact with his father, he's living with the mother, so it's all right. There's not really any need for the local authority. I'm paraphrasing section 37 report. And so matters lived on again until the psychologist was instructed, who disagreed with the local authority and said worst case parental alienation that he had ever seen. And at that point, the court then made an interim supervision order of their own, asked the local authority to rock up to court, and care proceedings started. By this time, some 2 and a bit years had gone past. 15-year-old child refusing to speak to his mother, family placements had broken down, and he now, for the rest of his minority, is in a residential unit, having supervised contact with his father because the father is considered to be such a risk to him. And sadly, at the moment, we're in contact with his mother. It's hoped that some contact will progress. He has been more receptive to her since he's been removed from the father. But listening to the father give his evidence, I would say was one of the most chilling things that I have seen. And it was clear that this father had no insight. One of the questions he was asked, he was referred to some evidence in the psychological report, was about the impact on his child and the loss of his family and what it may do to his mental health moving forward. And he was asked how that made him feel, like his son may end up with psychological psychosis. And he just shrugged. And so that's why I raise as in private law update how important it is to identify those cases where there have been coercive controlling behaviours and parental alienating behaviours, and to challenge the outcome of any Section 37 report, to challenge any CAFCAS report that comes in afterwards, to make sure that we do the best that we can to protect these young people from ending up in the situation that this young man ended up in.